So the conversation we're going to have here today is not going to be so much using, and there are tools obviously to use AI to write applications. That's a different conversation. We'll probably talk about that a little bit in the next panel. This one is going to be more of a how do I know what I've got? How do I discover what my people are working on? How do I, and then what do I do to protect it once I know all those hows? So we have, I'll introduce the panel as I've done from left to right. We have Matt Cole, and Matt is a partner with Saul Ewing, and he represents clients in commercial litigation, intellectual property matters, and data privacy issues. Thank you for being here, Matt. Next to Matt, we have Gary McFarland, and Gary is a senior patent and IP attorney at BAE Systems, and he joined BAE in 2021 after working with Boeing's intellectual property team for over a decade. Gary, thanks for being here.
Thank you.
And then last but not least is Austin Walters, and Austin is currently the founder and CEO of IP Copilot, and he is a researcher for artificial intelligence, machine language. He's a prolific inventor, and by prolific I mean he has 500 granted patents in his name. He formerly worked for Capital One prior to starting IP Copilot. So we have a great panel here. What I'm going to do is going to start it the way that we've started all the panels, just to get us going and get the conversation flowing. Matt, we can start with you, and then Gary will go, and then Austin in the order I introduce you. When you hear the topic, using AI to discover and to protect, what do you think people should have front of mind as we start the conversation? Matt.
Sure. Thanks, Gene. So I think that front of mind that the use of AI to discover and protect IP should be intentional. And by that, it should be part of a company's larger intellectual property strategy. And we've heard a lot of discussion these last couple of days about risk management. And when using AI to discover and protect IP, you have to have an AI policy and a strategy that complements existing policies and leverages them to protect the company from the risks, such as your data loss prevention policy, your cyber policy. But you also have to look at AI not through the lens of just as risk management, but viewed also as an opportunity to do all these new things and develop trade secrets and other inventions that may be patentable.
Great. Thanks a lot, Matt. Gary, how about your preliminary thoughts?
From the outset, I'm afraid I'm actually going to be repeating that which many of the other folks have said already. If we're looking to AI, particularly on the protection side, we need to understand, one, what the technology is, what it's doing, and once we actually have a good understanding of what it is and what it's doing, we can leverage the variety of different methods of IP protection that are available to us. It's not, despite my background in patent law, it's not all about patents, as Sri said earlier. You know, there are a variety of different methods that we can go ahead and protect the intellectual property that is being generated both by your company as well as by your company with the assistance of AI. And we need to be able to really understand what that technology is to really maximize the protection level for that particular aspect of intellectual property.
Awesome, great, thanks. And Austin, your preliminary thoughts?
Yeah, I think one thing to note is that AI has been used for decades, really, in protecting your IP. If anyone has ever been in part of a large corporation or a law firm, you likely have data loss prevention solutions, which are scanning documents that you're emailing out or stopping a thumb drive from taking some of your IP. That's part of typically some sort of trade secret program, or just protecting you from people taking PII information generally. I think with the new advent that generative AI allows is more proactive types of systems to both identify what should be protected, but also help more robustly protect and kind of implement a more robust data loss prevention program.
Okay, great. It's a good start to the conversation. So let me remind everybody this is a CLE panel. We have the articles that will support that CLE up on the panel URL, so you can go there and download the materials if you're interested. And one of the things, guys, that we want to talk about, it's come up a little bit so far, mostly me mentioning it during the trade secret panel about cataloging trade secrets, and I find it hard to believe that people don't want to do that. I understand the legal concerns. I think they're a little overblown, but I don't understand not wanting to catalog those things that you are paying people to innovate and invent. I don't get that. You have to know what your people are working on some level that matters. And let's start there. Am I crazy? Am I overstating it? How important is it? Let's have that conversation to begin. Matt, get your thoughts.
Yeah, I mean, I feel like that's an existential question among trade secret lawyers: is how big do you go, if at all? And I think I share the view of some of the other panelists earlier in the day that you at least need to identify your most material and principal trade secrets. And I think the concern you raise about you're crazy not to do this, you should be doing it, from someone that litigates trade secret cases, oftentimes on behalf of the plaintiff and as the trade secret owner, and you're interviewing people in the R&D departments and engineers and trying to understand how the project unfolded, what they did. One of the things I've realized that these people are very busy, right? And they have ideas or memorialized information in different documents. They might not have the time to sit there and synthesize what's in an email from somebody else, or that they sent to somebody else, and go into a SharePoint or some other protected database and sort of put that information together. So I think a lot of it is just the time constraints. But the identification of the trade secrets too is an issue where employees might not realize they have created a trade secret, for instance. So if they're landscaping the market, they're saying, we see this unmet need. We have this technology, we want to expand it into a different line or a different service. They might not realize that what they have is a trade secret. They might understand it's non-public, it should be kept confidential, they shouldn't disclose it to others unless there's an NDA in place, but they might not have sufficient in-house training to realize what I've got is a trade secret, and here's all the things I need to do to protect it. And there is some database to memorialize it, because oftentimes a company might have an internal patent database where you can identify potential patent disclosures. There might not be a similar database for trade secrets. So I think some of the concerns you raise might be a practical limitation.
Mm-hmm. Gary, your thoughts to that? I mean, what should people be doing to understand what they have?
I'm actually full agreement with you, Gene. I can't envision a situation where I do not want to know about the trade secrets that are available to me in my company. And this goes right back to the idea of understanding your technology, what is it doing, and how you want to protect it, because there is no one-size-fits-all method of protection for intellectual property. And it is very rare that you will have an engineer or a researcher that is familiar enough with all the different aspects of intellectual property law that they can effectively select and choose what aspects, plural, of intellectual property protection they want to apply to their particular intellectual property generation. I don't want to say to their particular trade secret, because that presumes that it is in fact a trade secret that we want to leverage. I also think moving forward, it's going to come into play even more significantly in the patent world. In the patent world, we've had, the idea of an AI inventor is coming into play, and now we have questions regarding, well, can that AI inventor be, in fact, an inventor? The Federal Circuit has already come around and said, no, well, clearly an inventor has to be human, but that was a very special case. For those of you who are not familiar with Stephen Thaler versus Vidal, where they were trying to protect an AI-generated invention. That particular individual had a motive, and that was strictly to push forward the idea of AI as an inventor. Excuse me. Whereas the case law really supports this generalized idea, well, that's a sole inventor in this regard, but in reality is how AI might be used is leveraged as a tool where it can be a joint inventor. And once you get into those questions of joint inventorship, then we need to understand, well, what contributions did the human joint inventor provide into this particular patent in order to be able to obtain a patent? And if you don't trace all the data, if you don't know what contributions are being put into place, then you can't really effectively answer that question.
Yeah, and so both of you, and I'll get to Austin here in a minute. I want to go one more round with you guys, the legal guys, before we bring in the inventor here. But I think it'll be interesting to get the inventor's perspective on this. We focus a lot on trade secrets there in that answer, right? And the way I look at it, and you can tell me if you agree or disagree or where, but all of this stuff should start, if you're doing it right, as a trade secret. It could become the world's most valuable invention, the world's most valuable of all time single patent, highest value for a single patent ever, right? Guinness Book of World Records. And somewhere along the way, it should have started as a trade secret. An idea that then reached some level of conception. Now it's like, oh my God, this can make us money. We got to keep this secret until we file, or that sort of thing. So I think that if you're not trying to catalog or in some way or document in some way what your people are working on that they think is innovative and secret, you're never going to get to the point where you have something that you know about as the business unit, as the CEO, CTO, general counsel, chief IP counsel, whatever, that you know you should be filing a patent on, right? I mean, it seems like if you aren't doing it, then you're relying on the people who are frontline scientists and engineers to decide what reaches the level of getting a patent application. Whereas if you can sit back and occasionally you have meetings and you look at what everybody's working on and there's some way to get your arms around it, then you as the professional can be making those determinations in consultation with engineering and other business units. Would you agree, Matt? Where am I missing? What elaborate if you like?
Sure. No, I think one of the fundamental points you made there is sort of unlocking the value of it, right? And how do you even do that if you don't recognize that it is a trade secret? And you find a way to commercialize it. And, that's why I think that, especially now in the age of AI, and even before AI became so popular, one of the things that I've really been seeing within in-house legal departments is the emerging importance of hybrid portfolios. And you might want to publish certain things in the patent, but withhold other aspects of an invention that, for a time or temperature or whatever it is, dimension you don't want to disclose. And that's really like a business decision as opposed to strictly just a legal decision. And you have to understand, what aspects are going to give us the best advantage in the marketplace. What do we not? What we want to keep secret forever, keep protected forever, as opposed to have in the public domain and have a limited lifetime of protection. I think you have to sort of incorporate some of the business considerations there as well as with the IP.
Mm-hmm. Gary, your thoughts?
My thoughts are, well, again, very similar in that regard. I think many of us fall into this trap of this idea where we say, hey, we want to get a patent. Okay, why? And there's no real fundamental understanding as to the why. There's no strategic analysis as to why you're going to protect it, how are you going to protect it, and not only that, I've never had an experience where I've worked on a industry blowing, patent in my life. What we've always had is patent portfolios, many of them operating in a particular technology area to provide a competitive advantage. But that takes a strategic analysis. You look at hybrid portfolios, as Matt was indicating. Well, what are you trying to protect? Are you trying to protect the device, how it's used, the methods, or the data underneath it? Is it the software? What's available to you? And the larger an organization gets, let me just not generalize, but in my experience, the larger the organization gets, the more challenging it is to identify and capture that intellectual property. The capture process has always been the redheaded stepchild of the IP legal groups. It's just kind of been sitting back there. It's like, okay, you got to go find it with the engineers, do your presentation, so it puts them in the forefront of their mind. It's really not enough to kind of just stay there and do that. We have these tools. We know that the intellectual property is out there. We know it's being generated. We as in-house counsel need to be proactive in terms of going out and selecting things. And that's where I think devices maybe perhaps like IP Copilot come into play, or other AI-generated systems where we can actually analyze inventors' backgrounds. We can analyze requests for proposals. We can analyze where budget is going, who people are working with, all these different aspects to say, hey, now that we put $10 million of R&D into this specific radio type that we know the U.S. military, in my own field here, the U.S. military is going to be leveraging, who do we need to talk to find out the details about that particular device, how it was developed, and how we might want to protect it?
Yeah, absolutely. I couldn't agree more. And that is a good segue to bring Austin into the conversation. So, Austin, you've got a lot of patents over the years. And so you've got, I think, two unique ways to contribute here to this conversation. One is to give us the inventor's perspective. How useful is this cataloging from your perspective? You're obviously a very, very smart guy. But I would think that having some way to catalog what what you're working on as you're working on it would also help you in the inventive process. And so I'd like to talk about that. And then also talk a little bit about why you moved from inventing to try and help with the, I don't know how you would describe it, I'll let you describe it, but the processes that you have in place that help mining, for lack of a better way of describing it. So.
Yeah, so I think So when I started kind of the inventing process, I didn't know, for instance, Capital One had a IP program at all. So I used to go out and give presentations, giving away all of our trade secrets all the time. And that was kind of the humorous part about it was like when I was originally approached, we were actually about to give a paper presentation on a bunch of stuff. And what ended up happening was they pulled us in. We're like, we need to get provisionals now. I think part of it is like as an engineer and as like I was leading in a applied research group, like our output is research, and like that's what I was tasked with. My task was not necessarily to get trade secrets, not necessarily to get patents, and at the time, no one told me it was like an imperative, so we didn't focus on it. Engineers are very busy, you know, they just want to get through their deployments or whatever. They don't honestly care about any of this stuff. So the trick is, and this is how I kind of came to IP Copilot and what we were looking at, was like, how do we automate that process as much as possible? Because as an engineer, I don't want to deal with any of this. I just want to get my code deployed. And so what we did in terms of IP Copilot, but even as a team when we were inside Capital One, when I was leading that team, was we would sit down every week and we would talk about what are we doing. And then we started going around Capital One and meeting with other teams and showing them how we did our process of basically mapping out what we were working on that week or month or whatever, and then sending it off to the IP Council to look at. That both helped us develop better products because now we actually like talk about all the like potential innovations, but also obviously it produced more patents, it produced better research. And what we try to do with IP Copilot is automate that process in terms of basically monitor various documents, and we can identify when there's innovations in those documents that could be potential trade secrets, and then we can highlight them to internal counsel to make a quick review on, similar to like a tweet, you swipe left, you swipe right type of thing, whether or not you think that's an innovative idea.
Great. I mean, that to me just makes a lot of sense. You know, I've had people tell me, engineers, well, not engineers so much as legal teams tell me that, you know, that their engineers don't see their job as getting patents. And that always surprised me because it's like, well, what pays for all this? You know, it's you're not licensing your trade secrets, you know, and but it is the reality. It is what it is. You know, at some point, you know, when in Rome, do as the Romans, right? And if your engineers aren't seeing themselves as that, playing that role, you still need the information, right? I mean, maybe Gary and Matt, you can talk about this. You know, the secret that everybody knows in the industry, in the patent industry, is that the real inventor is the patent attorney. In like 95% of cases, right? And everybody laughs, right? Because what happens usually is the inventor shows up with a cryptic paragraph, maybe if you're lucky, 2 cryptic paragraphs, and then you have to turn that into maybe a 75-page application. It's like, who contributed what here? And so, but this is a way to kind of deal with that. I mean, thoughts, Gary, or Gary first?
Well, so kind of speaking from my own perspective, before I joined BAE Systems when I was at Boeing, I actually tried to develop much less effectively than what Austin did, a very similar tool, leveraging machine learning at the time. This is pre-GPT and all the attention mechanisms and all that stuff. Just trying to leverage natural language processing and social network analysis to be able to pick apart and identify inventors that might be able to capable of providing me high-value inventions. Whether it was successful or not is a different question, but I was something I was trying to, that kind of led me down this route, and it was something we were trying to do. But there is a cultural dynamic within many large organizations, particularly in the defense world, which is what I'm most familiar with, where if an engineer is not charging a particular program, they're in trouble. They cannot charge the company, they need to charge a program. But if you're going to seek patent protection, well, then you're charging the company, and so essentially it's a no-no. So there's a little bit of a cultural dynamic with upper management saying, hey, look, I care only about my budgets, I just go solve problems, engineer, that's what you do. But in that solving of problems, my argument has always been, well, then if the job of the engineer is to solve problems, then what you're really telling me that the job of the engineer is to develop intellectual property, and how do we go ahead and protect that intellectual property that we're investing so much money into? There is definitely a cultural misalignment in there that I'm very familiar with, and it sounds like Austin is as well.
I just wanted to chime in. So when I was at a little bit of a story, when I was at Capital One, the thing is like the IP and legal department is typically outside the engineering department. And so what ended up happening is when I was getting all these patents, my VP, MVP, and multiple people above him were calling me, and they're like, why are you guys spending all your time writing patents? Why are you spending all your time, like there's bonuses involved, or like you're spending a ton of budget here. And basically we had to get the legal department involved to explain it. And I think that's also like part of it, right? Is like, that's not my job. My job is to deliver product. And I think that's also like a dichotomy that could be resolved honestly by just some sort of priorities, making it clear.
No, I agree. I think we need some, in many larger corporations, definitely some top-down leadership to push down and say, look, this is important. And tragically, the only time that really comes about is after your company has been smacked, really hard with a good patent litigation case.
Yeah.
Or the opposite. I was going to say the point you raised, Gene, is a good one. As someone who does plaintiff side trade secret work, you want to be able to. Well, the first interrogatory you're going to get from the defendants is identify your trade secret, right? And so if it's not listed somewhere, and you're trying to sort of reconstruct it by talking to people, interviewing engineers, or going through documents and trying to put the story together, you have a much harder, I think, time convincing a judge that on summary judgment that your trade secret is not too indefinite, it's not too vague. Here's what it was contemporaneously with the work. I'm not just doing this ex post facto for litigation purposes.
Yeah, and let's go down that path just a little bit if we can, right? Because as that's going on, you're in litigation, and one of the first things you do as a litigator when you sue somebody is protect all emails, don't delete anything, et cetera, et cetera, et cetera. And the last thing you want is a bunch of emails going, memos being created, going back and forth, saying, oh, hey, we have to do this, get on this, give us the, blah, 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 blah. When in fact, just reasonable, responsible document retention, which is another way of saying document destruction policies, as long as they're not in response to litigation and they exist, there's a whole lot of stuff that you as the litigator would really not want anybody ever to see that they don't have to see if you've gone through document management in a responsible way. Can you talk about that a little bit?
Yeah, I mean, I guess I would even step it out even further, right? You want to make sure you have those processes way before you file suit, because you want to do a very solid investigation. And that could be a months-long investigation, unless you feel there's a real need to run and try and get some TRO or next party seizure. Good luck getting that. But if you're trying to really identify a trade secret that has not been identified, and you're combing through emails, or you're looking at various documents collected over time on a project, talking to different folks, it is a challenge. And I mean, one of the very first questions I ask in-house counsel when I have that conversation with them is, do you have a litigation hold in place? Who's covered? What's covered? And now, even in the age of teams, right? Your team's data, is it being saved? Is your Slack data, is it being saved? Now we get to ask, are your chat GPT prompts being documented and memorialized somewhere? And so it is a big problem, but is one that's manageable if you sort of have a good IT team to work with internally and at your firm to sort of manage the processes and know who to cover and know where to look.
Yeah, and we'll probably be talking about this tool next year, right? Because there'll be AI that goes through all of those things, looking for the stuff that you don't want anybody to see, right? And the last thing you want them to find is an email or some communication somewhere to say, we've never documented anything. We need to document this because this needs to be a trade secret. Who has documentation? Does anybody have any documentation to prove we did anything to protect this? It's like, that's probably not the kind of communications you want. I would think these things thought out in advance. But that's just me. I mean, it has a lot of advantages to know what your people own and what your people are working on.
Yeah, I mean, one question you get asked is, well, if you don't know what you own, how can you say that you've taken reasonable measures to protect it? Right? It's almost like a dooms loop, where you can say, well, I take reasonable measures to protect everything, but you have to identify your trade secret with a very high level of specificity.
Okay, so then, Austin, let's go back to you. So how does this get done in AI? I mean, how do you train AI? And maybe let me even take another step back and talk about, because I continue to remind myself more than anybody, I suppose, there is no such thing as an AI. There is a bunch of different deployments, different models. We've been talking about the one that's going to eventually kill all the humans for most of this program. But there's tools. They're discrete tools, right? So are we talking about a generative AI? Are we talking about an earlier predecessor to a generative AI that's not generative, but is still artificial intelligence? I mean, how do we get our hands around the type of information that an innovative company owns?
Yeah, so I think I'll actually talk about kind of like a data loss prevention solution and how that typically works. So most data loss prevention solutions, that's like if you're trying to, keep some sort of document internal that might have PII information. So one of the examples is it just scans text and it tries to find a 9-digit number that might represent some bank account number. That's like a very simple system. It could use what's called regex or regular expressions. It doesn't even need to be AI per se, but it stops you from taking those documents outside of the company via email, say emailing yourself personally or whatever, and it blocks you. I think Microsoft offers this by default. That's actually one of the things my team at Capital One ended up working on, and we used AI to help then make it more robust and capture things like addresses, which can't be captured with regular expressions. And then we open sourced that library and made it available. What we're talking about when we're talking about kind of more robust solutions that are trying to identify ideas, you have to somehow take that information and compress it in a way that the system can then look through it. So you either want to subsample documents in critical locations, and then you could have a generative AI, look over it and say is this document similar to other documents I've seen? That would be like a simple example. But I think ultimately what you're really just trying to do is match things to other things, right? So first you have to build an index of what you find valuable as a company, and identify and create a catalog of those ideas. Once you have that, there's a lot of different techniques you can use to then try to essentially stop that from being exfiltrated in some manner, or have even like a simple system where you just when you leave a company, you end up getting a document in some cases where you sign and say yes, this is the company's IP. Things like that. I won't go into details about our particular solution, but those are just examples where AI could be used to help stop things from being taken, or reasonable measures being put in place to stop documents from being exfiltrated.
And what so do these tools exist to allow people to really use AI to, and by people I mean like lawyers or the business people, to know what is really going on in their engineering shops, what people are really working on? And I thought, Gary, I never really thought about using these to identify your best, brightest engineers, as I think you kind of suggested you were trying to do. But that would be a great tool to have, right?
So, you can speak to what you built, but we actually, I developed a patent on this exact topic, which was identifying the expertise of everybody at your company. So you identify the expertise of the individuals, and then we look at what they're talking about, and then so if you have expertise in a topic, and then you're talking about a particular topic, right? We then say, okay, you have the expertise to potentially develop that idea, and you're talking about an interesting idea. We do that using actually some various techniques I'm not going to go into, but that allows us to quickly subsample, like I was talking about, of who might be interesting, and then you can target those individuals.
To my end, actually, it was similar to that, but it wasn't just necessarily the the individuals. I had this generalized concept that brilliance is contagious. So you'll have sometimes a group of, let's say, 5 or 10 engineers working on signals analysis, whatever it happens to be. And within that group, you might have one PhD that's absolutely brilliant, but that one PhD is working with 9 other engineers. And, they share ideas, they talk, and now all of a sudden you've got, some kid straight out of college that just bought in, just side thought. It's like, well, what if we did it this way that the PhD maybe isn't thinking about, but maybe I do want to talk to the kid right out of college. Or more importantly, you can leverage those connections to promote a culture of IP awareness, where you can say, hey, look, Austin has got 500 patents to his name. He's working with Matt. And I can say, hey, Matt, what do you want to know about the patent process? Austin has been doing this, that, and the other thing. Are you interested? Do you have any ideas? Just to kind of almost develop a IP champion without necessarily putting the burden on the IP champion,
Yeah. Matt, any thoughts on?
Yeah, I was going to say the technology already exists, to identify common concepts among documents and different custodians. I mean, it's used in e-discovery, right, all the time for case development purposes to see what two people were talking about and identify their most important emails, the most important documents, and to bring in common concepts. So if they talk about a contract, an agreement, an understanding, an arrangement, you can do that. You can do that internally within a company. So if you have an engineer who is talking about some very technical term, and they might have as part of their innovation team, not just engineers, they might have like clinical consultants. And you can sort of build sort of logic to identify what are the terms they're likely to be talking about, who are the individuals, and you can map that out with sort of a who-to-whom analysis.
Yeah, there's a lot of potential here, but as we say in the explanation of the panel we're going to talk, it's not without some risk, and it's not the risk that we've been talking about specifically as much as I think the risk of doing it wrong. And if, for example, like if you were using one of these tools, I have in my mind now, for example, is if you're using one of these tools that can collate, for lack of a better way to describe, the information and knowledge that your folks have, and then there's an AI component that maybe takes that and then starts to suggest or facilitate. At what point in time do you have a situation where the AI is the inventor, which they can't be the inventor, which creates a whole host of problems for ownership from the company's perspective? Or at what point in time is the AI really just a co-inventor and it maybe has identified some patterns that the individuals had not appreciated yet, but now that they've been alerted to it, now they come up with something really cool or exciting. And how do you solve for that, or how do you deal for that in identifying the inventors, and how do you solve for that with respect to making sure that you've put in enough in the application to make sure that it really was the individual, the person with a heartbeat, who is at least one of the inventors? Thoughts on that, Gary? I think you kind of mentioned that a little bit when you were talking about the Thaler.
So yeah, I think the critical aspect when it comes down to patent world is what's been kind of said a lot here, and I'm going to repeat Shree's quote that I had lunch with him earlier today. He said, which was much more articulate than I could ever be, patent law was developed for the industrial age, but we are now in the information age. So we are now in this situation where we are trying to jam this square, software invention peg down the old, abstract idea hole. Same thing that applies with the inventorship. We have this idea that an inventor can only be human. So now we're trying to kind of manipulate all our software developed inventions to fit this concept of an invention created by a human. What's really interesting to me, from my perspective, is the simple fact that this isn't new. We've been doing this for so long, and it wasn't until Thaler came around that said, trying to push this issue that it became to the forefront. But in the past, there have been genetic programming. For those of you who may not necessarily be familiar with genetic programming, it's this, I'm going to paraphrase it here. It's kind of a machine learning approach where you put some guidelines on a bit of code, and you say, this is how you're going to work with all the other bits of code that are out there, and then you put randomized perturbations within that code. So you're changing some parameters, you're changing some modification, and then you put it out there to, for lack of a better term, breed with all the other pieces of code. And then whatever comes as the result, we make a determination as to what does that result do with a loss function. The better it gets with relation to that loss function, the better the actual invention is, and so you get the very end, you've got this thing that you end up calling the invention. That's 1,000% the system. That is not a human being. That is the system going through random perturbations and generating a result. And yet there have been, by the last count from everything I've read, at least 50 patents that are easily identifiable as having been developed in that particular way. It's just that we haven't really talked about it in terms of, hey, it was the computer that invented it rather than the person using the software to invent it. So moving forward with this particular area of law, when it comes out to that inventorship question, we are going to have much more of those, looser kind of factual legal questions that we need to try to put our assessment of who the inventor is, and as everyone who's read the Panu case and their subsequent cases, the inventor has to make a significant contribution that isn't insignificant in comparison to the rest of the invention. Identifying a problem isn't making you an inventor. Leveraging the tools and making an inventor. Paying somebody else to make isn't going to make you an inventor. So you do need to be able to identify what that human being's significant contribution is, compare it to what the AI did, and that circles right back to your original question of, do we really want to know what everybody is bringing in? And the answer for me is absolutely, because if you don't tell me what the people are doing, I can't determine what the contribution is. I can't make that argument.
Right. Matt, you're shaking your head.
Yeah, no, I agree. That's why I think documentation is so critical to identifying sort of what the invention is. If you're designing a system to develop a solution to a specific problem, it's potentially a different call, right? And you have this sort of framework of, well, he's just my research assistant. Do we play that? Does that paradigm work for AI? And who has the ultimate control? I think, to what Gary was saying, now that the PTO's guidance came out and they have this substantial human, and it's the same framework it's always been, right? Substantial human contribution, but now litigating the edge cases are going to be the most interesting ones. And you have to sort of look at with the Copyright Office, and this was talked about yesterday, substantial human contribution, significant human involvement, two very similar seeming concepts. Are they going to end up having a different meaning, leading to different results in IP protection?
Well, I'll tell you what keeps me up at night is actually from that same PTO guidance. If you look into details, there's a section where the office is going to instruct examiners to be more focused in terms of actually having a human contribution in there as an inventor. If you look back historically, as the PTO has been trying to wrap its head around software into this square abstract idea, PEG, that whole generalized idea, for those of us who practiced shortly after the Alice decision came around, we all knew what a mess that was. And now my biggest concern is that we're going to have a whole bunch of examiners coming around, and they're going to say, okay, well, I need to know who the inventor is, and a billion different standards for, hey, was this significant? Was it not significant? And I don't know where they're going to go with it.
I actually have a different question. What happens when you can just generate an infinite amount of patent documents and just publish them, and then what happens?
Yeah, and interestingly, some of the law review articles are lining up with exactly that. What does that do to the fundamental purpose of patent laws and copyright laws in general? To advance the progress of useful arts and inventions, I think is the constitutional term that's in there. Well, what happens when you undercut that entire foundation by creating a system that just spits out all sorts of garbage, and now we've got a prior art base that's significantly larger than it already is. It becomes a bit more challenging, but that's for folks well above my pay grade.
Well, but it also is something something we're going to have to come to terms with, right? Because on some level, Jay Walker, the founder of Priceline, told me this a long time ago, and he in an interview we did, and he said, you can't invest in what you don't own. And what we want as society, we want certain innovations, and we're fine with innovations that, I've seen on TV or QVC and, stuff like that. That's great. That's fine. It's cool. Gadgets are wonderful, and the inventors are creative and that sort of thing. But what we as society want, we want the cure for cancer. We want all kinds of things that cost a lot of money to bring into being. And I wonder whether most people even have any idea, like how much does Apple spend on bringing into being their next operating system? How much has IBM spent on trying to create Watson and all the various implementations in Watson? The amount of money, even for Apple, which they're not to say it's insignificant, but would pale in comparison to the Watson project, is many, 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 many millions and many tens of thousands of man hours on an operating system, right? If you don't own it, you can't do that. You just can't possibly invest. So we're going to have a conversation at some point in time, I think, about not only like what is the goal here? If we really want to benefit society, like the Constitution says is the goal, we're going to have to protect things that with some way, some maybe sui generis right. Otherwise, people aren't going to be able to pursue them. You know,
Right, they'll be disincentivized.
totally. And so, but now, Austin, I want to come to you and ask you. We've been talking about this, like, how do you get your arms around what your company owns, what your engineers and scientists are working on? But it's more than that with AI, right? It's like you want to get your arms around everything that your people have been researching and documented to the greatest extent that they're able to do so. And you want to do it in a way that they really probably don't have to spend a lot of time documenting it, but that you as the company have it. But then you're going to want to either now, and maybe you could say whether this exists now or when it will exist or how good it is currently. It would be great to be able to run AI across everything that you know, that you've documented, to give you these relationships or suggestions that you otherwise wouldn't have thought about. Right? Are we there yet? How long are we there? Is it good yet? When is it going to be good? Are there people working on it? Are you working on it?
Yeah, a few things, right? So I think it's important to document, like, I think what you're going to end up finding, if you ran AI over just a random company's documentation, you'll realize that like half the, or probably more than half the engineering hours is spent on the exact same problem in multiple silos, and no one knows what the other one's doing. So I think that's honestly the first problem to solve, is make it accessible to everybody. And then you get more innovation like outward into new space, right? And that will naturally occur. And I think that would actually help benefit companies the most. I think also what you were talking about in like terms of predicting kind of where companies are going. Yeah, I mean, we're working on it, and it is a thing that you can do. The ways you do that, I think, are, and like the accuracy of that is like ultimately up in the air, right? Because I think like if there might be a new discovery in some sort of chemical, right, that would change the calculus in what you do moving forward. But in terms of projecting out what people are working on, I'm sure I know there's tools that already enable that to a degree, in terms of saying like, you know, your competitor is developing X, Y, and Z. You know, they can look at news articles and see that. We know for a fact, for instance, Meta is working on Llama 3 because they published that. It's presumed they will continue on that trajectory, right? And all AI does is it predicts the next thing. But it can't predict what's often called like a black swan event, or an event that was unknown or unpredictable. And that's
just to some extent what I'm asking. I wouldn't call it a black swan as much as like maybe an off-white or a gray swan. But, you know, I have in my head that, you know, because I know that there was some tools. For example, if you were able to look at Apple's portfolio many, many years ago, you would have noticed, and it was all there, anybody could have seen it, but with tools, it became really very apparent that they were interested in watches. You know, and it's like, well, why is Apple, I mean, they're getting a lot of IP in this space. They were getting like 5, 6, 10 times the IP of any watch company in the world. You know, and it's like, and this is years, this is 5, 6 years before the iWatch first, you know, appears. You know, so if you had seen that or know that, you're like, okay, and you're a watch company, you might have said, we've got a new competitor, a new entrant here that's taking this very seriously. We need to either figure out what's going on. Is this something that is just they're patenting things and they're not going to do anything with, or what does this tell us about maybe the competition we're going to be facing in a decade? Now, the thing though is you got to know. You got to look, but with AI tools, at some point, the AI will maybe, I would think, alert you and say, hey, watch companies, look over here, pay attention, right? I mean, that's not fanciful.
No, it's not fanciful at all. You could also, two things. One thing that we noticed as researchers was publication. People would stop publishing. So they wouldn't publish. So for instance, Google was kind of famous for this. They hired all the deep learning researchers, and then deep learning research died for 4 years. And then they were like, okay, now we're going to start publishing again. And they published all their deep learning research, which led to all of this. But I was in that research space, and we were all looking around like, where is everything? I think in terms of AI, you still have to direct it to a degree, right? So you still have to, like, it's not all-knowing or anything. You have to come up with techniques to basically dive into that. And there's definitely techniques to do that, and you can also map out trajectories of like publications or what they're talking about in their patents, things like that. It's definitely doable.
And like, okay, so like when you hear about this stuff that's being used, and what I want to ask is, I mean, how excited are you? I mean, because that's going to be a strange question to most, but in this space, we get excited about what we do. It's cool, it's exciting. You can immediately think, oh my God, I can't wait until I can use that for X. Gary, and I want Matt, you to answer that same question. So what excites you about this?
Oh, well, first of all, I'm very excited. I am excited, but I'm a tempered excited because I think I think more is being made of the concept of AI right now than it really deserves. At the underlying foundational level, I think the difference between the machine learning algorithm that is kind of generating the whole ChatGPT, boom right now, and the old machine learning algorithms really isn't that significant, and I feel like there's a smaller window in terms of, what you might be able to leverage that for. But that being said, I think it's exciting that our companies are getting, excited about it. And I think that puts us in a good position, all of us here as technologists, as well as attorneys, to really leverage this to support your individual business unit's goals. For my own department, within contracts, for example, I might try to use that to hunt down old contracts that just got re-upped essentially for 30 years or something along those lines whenever I need to find a provision or something along those lines, or e-discovery, or something that's kind of already there. It can be leveraged and improved upon with AI. But what I'm really curious about is the connections that I don't know about. And I think that's where it's going to excel, where I can say, okay, well, where are the things that I was not considering? So by way of example, I remember before I was doing legal work, I worked in the intelligence world, and I remember one of the things that the guys talked to me about is like, one of the things that will be considered is a drive-by of the parking lot of a defense contractor. If you're looking at a whole bunch of shiny new cars, the people that are working there are working on something that's a long-term contract, that they're not worried about getting fired tomorrow, and that gives you bits of information that I would have never considered, So I'm curious as to like identifying those shiny new cars kind of a thing.
That's great. I love that. That's insight that you didn't know you could get, but then when you hear it, it's like, oh, that makes all the sense in the world.
Yeah.
Matt.
I'm excited about the accessibility of the tools, not just their adoption, but it's almost democratizing, so the inventive process, the innovative process, and giving smaller companies the opportunity to say, okay, now I can recognize what my competitors are doing. I don't have to hire a team of 30 engineers, have them sit in a room for 3 months, read scientific literature, read patents to figure it out. Engineers get tired, they're human, they make mistakes. I can employ a program, get results in 2 hours. If I think that they need to be tweaked, I can tweak it and possibly get better results. And it just gives smaller companies more opportunities to identify what they have and see where things are going among their competitors. And to the point you raised earlier about companies saying, well, maybe Apple is going to get into the watch market because they're filing watch patents. I mean, what's to stop a company from filing a patent on every single thing that they think of and throw their competitors off the trail that way too, right? And sort of just swamp the market with IP and sort of defeat the AI at some level, or attempt to defeat the AI at some level by doing that.
Yeah, I mean, there's going to be intelligence, and then there's going to be counterintelligence opportunities, and as the AI models get better, they'll be able to figure out which is which, I suppose, and it will be probably almost like a global thermonuclear battle where one side gets better, and then the other side that tries to throw it off gets better, and back and forth. But does anybody have any questions about anything? Okay, no question. So one of the things that we also wanted to talk about is as you're using whatever tools you're using to try and okay, so I'm going to assume you are that person like Gary and I, like you really care about what your people own or what your people are working on, and you need to know, and you decided, I want to know, and I'm going to invest to know, and I have some tools to figure out and know. How do we decide now what it is that we're going to want to keep as a secret, and how do we decide what it is that we're going to want to try and get patent protection on? Because if you're using that kind of tool, it could be a tsunami of information. Now, most of that is going to wind up needing to be trade secret just for financial reasons. So how do you sort the wheat from the shaft, I guess is the question. Gary?
So what we've done in the past and what I've always tried to do is work with my business development folks to identify an IP strategy at the outset. Whether or not it's for an entire business unit or for a single product, that's what's critical to me. The idea of developing your strategy afterwards just doesn't make sense to me in any kind of way. So I've always worked with folks to identify what we refer to as IP choke points and technological choke points. Those are the two technology areas. The technology that you need to accomplish something, or in form of intellectual property, what intellectual property do you need to accomplish something? And the choke point being, this is where all my competitors must pass to move forward. So if I got a technology choke point or an IP choke point, and it's in my business, my overall business's area of business, then I'm definitely moving forward and protecting that particular information. That being said, we also need to look at what's there. Some things are not amenable to patent protection. Things that are impossible to detect infringements. Why? If it's going to be, if you won't know that your competitors are using it in some private lab, why are you going to give your competitors the knowledge to accomplish that which you paid all the work, to do so? Haven't been on that end before. I don't think I'd be the first attorney to admit, maybe I will be, that I've actually told my engineers, go ahead and infringe. Because at the end of the day, that advice is a risk analysis. You make an analysis, say, okay, well, what's the likelihood of us getting caught? How many are you developing? What would that cost us if, company X came around and said, oh, wait a second, what's the life of the patent? All these different factors, what it'll cost to design around. And once that number is less than, what you would expect it to be for a patent infringement case, or more realistically, a license, then I think you're okay. So you make that kind of business decision, one, with your patents as well as your trade secrets or with any intellectual property that's developed.
Yeah. Matt?
Well, I'm outside counsel, so my perspective is probably very different than Gary's, but what I've seen work for companies is, and here's an opportunity for AI, is not just to develop a trade secret from the get-go, but to use it to see what the landscape to market, see what the opportunities are to, for instance, buy your competitor's product, right? AI is very good at object recognition, right? It can see things, it's good at sensor analysis, it can understand how products are made, you can do some kind of a simulation of it and understand how it works and how it's fabricated in a virtual environment, and you can sort of try to reverse engineer what your competitors are doing, or you can have it look at product manuals and scientific literature and understand how they're produced, or you could have it ingest dozens and dozens of patents and scientific literature and see where's the space and where are the opportunities here. And so I think that's a really interesting proposition for AIs, even before you get to the invention, the innovation point is to identify where are the gaps, where the innovations lie, and where can I go in and make that decision, well, this can be a trade secret, or I should file a patent here. And there is, of course, value in blocking patents and defensive patent portfolios.
Yeah. So Austin, the tools that are existing right now that people are using, what kind of insights does it give you? Can it give the users insights enough to decide, this is valuable, that's not as valuable, and I suppose it has a lot to do with how you train it and what you ask it to do, right?
Yeah, I mean, there are tools out there specifically even designed for researchers to help kind of like conduct almost like a prior art search on what exists today for yourself, right? Because if I'm developing a new product, so I'm tasked with developing a new product, I'm going to look at what exists today. So I'm going to do a literature review. I'm going to look at what patents exist, and honestly, I'll probably ignore anything that, whatever, when I'm designing my next system, and then I might send it, like when we design our next system, then we'll try to patent it, right? I think that's typically like the process, and then sometimes there's business decisions like ignore that patent, or even, for instance, one of the things we would do sometimes is like fund the research lab working on that product, so that way we get early access to the future iterations of the product. In terms of like, those tools exist, right? They help you kind of do the prior art analysis specifically targeted towards like research development. I think in terms of kind of like predicting like where things are going, and like all these tools will exist relatively soon if they don't already exist. So I think, for instance, like summarizing a manual and getting like a 5-step process, the AI is really good at that. So I mean, I use it for that all the time. I'm like, hey, here's a link to this 20-page paper, give me the 5 steps to replicate it, and like it'll just step right through it, and I can go and implement it. So I think like even if there's not specialized tools, even the generalized tools like GPT-4 will be usable for that kind of stuff.
So, and I guess one of the questions that I was asking, like on a very rudimentary basis, so if you were doing a search and using AI to help you do a search, for example, and then it came back and it's like, yeah, but you know, this market is really too small. You don't want to be in there. I mean, what kind of insights can AI already be used to give somebody, like that are not exactly what you asked it to do, but you know, a tangential but very important observation that the AI, I think, is probably capable of giving, if prompted properly.
So like our tool, for instance, does a prior art search if you give it a disclosure. And it specifies like this part's unique, this part's unique, this part's covered by the prior art. And then you can actually go through each piece of the prior art and see what's you know, overlapping. But what it could also say, like we specifically don't do this, but it's easy to do with our system, is you can say, well, what is a tangential thing I can implement to avoid this prior art? And it can do that.
Yeah.
In terms of the tracking stuff, I don't even know if we need AI necessarily for that. You know, there's a long history of citation analysis, for example, in patent world. So you can actually, you know, identify what your competitors are doing in your particular market space, essentially, simply by analyzing the citations. Now, of course, AI might make it a little bit easier. You could also use it to scrape the internet, to scrape product manuals, to try to identify who's doing what. And particularly from the trade secret perspective, what I envisioned is, you know, an ability to really track down and demand that certain information be pulled off of the internet. So, for example, maintenance manuals that you might want to maintain as your own individual trade secret for licensing reasons, for some future reason, you can find that on the internet and demand pretty quickly that it be taken down. But you need something to go search, and that's not necessarily AI. That's kind of already existing technology. You know, it's just thinking about it in a different way. So, you know, in the case of the maintenance manuals, maybe somebody was clever and they ended up, you know, trying to rewrite certain words, and okay, fine, now you're doing a cosine similarity analysis instead. You know, but at the same time, you can still leverage the device to do exactly that, to go chase it down and find out, you know, who's using your information and why they're using it.
Yeah. Matt, you look like you want to say something.
No, I feel like we've been talking about sort of using AI to come up with brand new ideas, right? But I think there's also a real opportunity to enhance existing products and services. And if it's, you know, optimizing, you know, methods, right? If you're in a industry with a heavy maintenance schedule, right, to optimize, like your logistics industry or airline industry, there's ways to use AI to sort of optimize those processes and maintenance schedules. There's ways to use it for product defect analysis, and in real time, you know, try and get those defects out of a product before it goes to market through simulations. And you know, I think it's not just what is new and different using AI, but what can we take that we have that's existing and enhance it and make a product line extension.
Right, right. I mean, like, here's a problem, define the problem, and search our database, our trade secrets and innovation database to find what do we have that could potentially be a solution to that particular problem. I mean, I think that those are the really potential, in the not too distant future, very exciting. And I'm sure there's some tools out there that could already do that to some extent. But you know, they're going to get better. They're going to get more insightful. And it's like well, if I knew to look at watches and I knew to look at watch patents and I came across Apple, then I would have known they were doing that. Well, but that's like, if I would have known, if I would have known, if I would have known. What I'm looking for is like the AI, and I don't think it's too far away, that is going to be suggesting, hey, there's a relationship over here that you haven't asked me about, but that relates to your query. That's where I think it starts, for our purposes and discovery purposes, gets very, very fun and exciting. And I don't know how long away that is. I mean, thoughts, Austin?
Soon.
Soon. Yeah, that's what I thought. I didn't think we were that far away from it.
So that's really interesting. So I guess, are you suggesting then that we are nearing the approach where an algorithm can, without a prompt, provide you information that it thinks you would find interesting in this particular situation?
So all the time, like anytime we go on the internet, right? Google knows everything about you, right? It knows probably when you use the restroom. It knows where you drive. It knows what you eat. It can predict where you're going to go tomorrow, probably. And I think ultimately we are there. Now the question is it accessible to you? The answer is no, it's accessible to Google. So I think we're getting closer and closer to the point where we can start predicting stuff that's meaningful to you and your profession because it can look at what data you provide it.
Okay.
And I think it's fairly soon that it's going to be able to say, we think based on like the engineers in your, this is, like where you're going in terms of an engineering culture, we think that you're going to be here in 6 months. And that's not even a stretch. Like it's just predicting the next idea that comes out of that chain.
See, and what I've seen just recently is, so I use Instagram largely to watch cute dog videos because I'm a dog guy, right? I love my dogs, and I love the German short-hair pointers. So I watch a lot of these crazy German short-hair pointers jumping and doing tricks, catching balls, all that sort of thing. There was a point in time when, like, if you clicked heart that you liked it, okay, well now you're going to get more stuff like that, right? I've noticed recently, because I've purposely stopped clicking on because I need fewer of those things in my feed, but if I scroll past something very quickly, okay, well, I'm not going to get too many more of those. But if I don't like it, but I pause and look at it and watch the video, even though I don't like it, then it's almost more powerful than having clicked like if I scroll past it quickly, because they know I'm interacting with that. And then I get a ton of whatever that was that I just took 30 seconds to watch. I have now a ton of those videos very similar to that just immediately in my feed.
But I think that's a fundamentally different situation than kind of what you were proposing a second ago. In that situation, Instagram has a goal. It knows that it wants to keep you locked down. It knows that it wants you to spend more time on that particular
Right.
system.
But that's what I think Austin was saying. Instagram has that. Google has that information, right? But so that information exists, but without me conveying anything that this is meaningful to me for whatever reason.
No, but
and that's what I think I'm getting at, because I don't think I'm getting, like the robots are going to rule the world quite yet, but
I think it can extrapolate your ideas though, and I think that's what I'm also trying.
And that's
to get
what I'm
at.
thinking about too. Like the next step is going to be based on my interaction with the computer. Will it start saying, "Hey, you seem to want to go on a beach vacation, right?" Well, hey, based on your portfolio of innovations at your company, you've got something here that you don't really know that you need or that you want, And I think we're pretty close to that information being capable of access by people and companies, and not just the people who are monitoring us to show us the ads to keep us engaged.
I don't. Sorry.
No. And I agree with you, both of you, in fact, with that. I guess where my confusion was, or at least where I was looking at things was, in all those situations, the company running the algorithm has a goal that it has articulated to the algorithm. What it sounded like to me earlier was that the system, the question was whether we were close to a point where the system doesn't know what your goal is, but thinks, hey, maybe you want this to be your goal. Maybe you want that user to watch a little longer, or in the opposite case, maybe you don't want them to watch a little longer, whatever it might happen to be in that particular situation. And I think, it was that articulation of that parameter,
Right, no, and that's the question. I don't know how far off we are from that, but I sense it's not that far. I mean, I could be wrong, but... And I'm just looking at, we're past time for this, but I want to give each of you the opportunity to wrap up. This is very fascinating, and it gave us the opportunity to geek out, or at least me, to geek out a little bit. I appreciate you going along with me. But how about we, in rapid fire, how about you give us your final thought? What's your takeaway message? And we can go across like I introduced you, Matt. How about we start with you?
Sure. I mean, a lot of AI is looked at now from a risk management perspective, and I agree that when AI is used for IP development and protection, you still have to look at it through that lens. But also, there presents tremendous opportunities like we've talked about. And so when you use AI, the strategy has to be intentional, has to fit the corporate sort of business objectives. And, with all the sort of law evolving from the patent space, right, documentation is key, and portfolios are going to continue to evolve, where trade secrets, I think, take on a more important role. And the importance of hybrid portfolios, I think, are really going to be where that trend is going to continue, I think, as AI is becoming more widely adopted and deployed within organizations.
Yeah. Great, thanks, Matt. Gary, your final thought.
I think it's going to be imperative for us as practitioners to really understand the technology. Without that base understanding, we don't know what we have, we don't know what we're getting, we don't know how we're going to protect it. So it's definitely well worth spending a little time learning about the technologies and how they operate. And I will give a big plug to Coursera, fantastic courses on machine learning and artificial intelligence right now, all for free.
Awesome, great, thanks, Gary. Austin, your final thought.
I would just say there's been a lot of talk about being scared of AI taking over the world and things like that. I wouldn't be nervous about that necessarily. I think really AI is just going to empower us to be 10 times more productive. There's an idea of 10x engineer, if anyone is in the engineering space, and really that's just going to do the same thing for attorneys, and that's going to produce more value to everybody, and that's going to actually create more work, in my opinion. So I think it's, you obviously need to mitigate risks, but I actually think there's a massive opportunity as well.
Yeah, great, awesome. Thank you very much for a great conversation.